Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Vidal v. Elster. In this case, the court considered this issue: does the refusal to register a trademark under 15 U.S.C. section 1052c when the mark contains criticism of a government official or public figure violate the free speech clause of the First Amendment? The case was decided on June 13, 2024. Steve Elster sought to register the trademark, Trump Too Small, for use on shirts and hats, drawing from a 2016 presidential primary debate exchange. The Patent and Trademark Office, PTO, refused registration based on the names clause of the Lanham Act, which prohibits the registration of a mark that identifies a particular living individual without their written consent. Elster argued that this clause violated his First Amendment right to free speech. The Trademark Trial and Appeal Board affirmed the PTO's decision, but the Federal Circuit reversed. The Supreme Court of the United States reversed the Federal Circuit's decision, holding that the Lanham Act's Names Clause does not violate the First Amendment. The court found that while the Names Clause is content-based, it is not viewpoint-based, as it does not discriminate against any particular viewpoint. The court also noted that the Names Clause is grounded in a historical tradition of restricting the trademarking of names, which has coexisted with the First Amendment. The court concluded that this history and tradition are sufficient to demonstrate that the Names Clause does not violate the First Amendment. The court emphasized that its decision is narrow and does not set forth a comprehensive framework for judging whether all content-based but viewpoint-neutral trademark restrictions are constitutional. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas announced the judgment of the court and delivered the opinion of the court with respect to Parts 1, 2, and 4, and an opinion with respect to Part 3, in which Justice Alito and Justice Gorsuch join. Steve Elster sought to register the trademark, Trump Too Small. But, the Patent and Trademark Office, PTO, refused to register the mark because the Lanham Act prohibits registration of a trademark that consists of or comprises a name identifying a particular living individual except by his written consent. Elster contends that this prohibition violates his First Amendment right to free speech. We hold that it does not. A trademark is a symbol or a device to distinguish the goods or property made or sold by the person whose mark it is, to the exclusion of use by all other persons. As we have explained, the principle underlying trademark protection is that distinctive marks, words, names, symbols, and the like, can help distinguish a particular artisan's goods from those of others. So one who first uses a distinct mark in commerce thus acquires rights to that mark, which include preventing others from using the mark. Trademark rights are primarily a matter of state law, but an owner can obtain important rights through federal registration. The Lanham Act creates a federal trademark registration system administered by the PTO. Federal registration of a mark is not mandatory, and the owner of an unregistered mark may still use it in commerce and enforce it against infringers. Federal registration, however, confers important legal rights and benefits. For example, a registrant may rely on registration in litigation as prima facie evidence of his exclusive right to use the mark. And, registration provides nationwide constructive notice of the registrant's claim of ownership of the mark. Only marks that meet certain criteria are federally registerable. Among other criteria, the Lanham Act contains what we will call the Names Clause, a prohibition on the registration of a mark that consists of or comprises a name identifying a particular living individual except by his written consent. The Names Clause excludes from registration not only full names but also surnames, shortened names, and nicknames, so long as the name does in fact identify a particular living individual. Steve Elster sought to register the trademark, Trump Too Small, accompanied by an illustration of a hand gesture, to use on shirts and hats. The mark draws on an exchange between then-candidate Donald Trump and Senator Marco Rubio during a 2016 presidential primary debate. The PTO examiner refused registration under the Names Clause because the mark used President Trump's name without his consent. The Trademark Trial and Appeal Board affirmed, and it also rejected Elster's argument that the Names Clause violates his First Amendment right to free speech. The Federal Circuit reversed, holding that the Names Clause violated the First Amendment. The court first concluded that the Names Clause is a viewpoint-neutral, content-based restriction on speech subject to at least intermediate scrutiny. It next concluded that the government could not satisfy even intermediate scrutiny because the Names Clause does not advance any substantial governmental interest. We granted certiorari to resolve whether the Lanham Act's Names Clause violates the First Amendment. The First Amendment provides that Congress shall make no law abridging the freedom of speech. In general, we have held that the First Amendment prohibits the government from restricting or burdening expression because of its message, its ideas, its subject matter, or its content. When enforcing this prohibition, Our precedents distinguish between content-based and content-neutral regulations of speech. A content-based regulation targets speech based on its communicative content, restricting discussion of a subject matter or topic. As a general matter, a content-based regulation is presumptively unconstitutional and may be justified only if the government proves that it is narrowly tailored to serve compelling state interests. Our precedents distinguish further a particularly egregious form of content discrimination, viewpoint discrimination. A viewpoint-based regulation targets not merely a subject matter, but particular views taken by speakers on a subject. It is also generally subject to heightened scrutiny, though viewpoint discrimination's violation of the First Amendment is more blatant. Because our precedents dictate that these distinctions inform our assessment under the First Amendment, we start with them to evaluate the Names Clause. In the trademark context, we have twice concluded that trademark restrictions that discriminate based on viewpoint violate the First Amendment. In one case, we held that the Lanham Act's bar on disparaging trademarks violated the First Amendment. All justices in that case agreed that this bar was viewpoint-based because it prohibited trademarks based only on one viewpoint, giving offense. And, in another case, we held that the Lanham Act's bar on trademarks containing immoral or scandalous matter likewise violated the First Amendment. We concluded that the bar was viewpoint-based because it prohibited trademarks based only on one viewpoint, immoral or scandalous matter, while permitting trademarks based on other viewpoints. The Names Clause does not facially discriminate against any viewpoint. No matter the message a registrant wants to convey, the Names Clause prohibits marks that use another person's name without consent. It does not matter whether the use of the name is flattering, critical, or neutral. The government is thus not singling out a trademark based on the specific motivating ideology or the opinion or perspective of the speaker. The Names Clause simply distinguishes between two opposed sets of ideas. Elster suggests that the Names Clause verges on viewpoint discrimination in practice. According to Elster, it is easier to obtain consent for a trademark that flatters a person rather than mocks him. This court has found that a law can discriminate based on viewpoint in its practical operation. But, here, there are many reasons why a person may be unable to secure another's consent to register a trademark bearing his name. Even when the trademark's message is neutral or complimentary, a person may withhold consent to avoid any association with the goods, or to prevent his name from being exploited for another's gain. Although the Names Clause is not viewpoint-based, it is content-based. A restriction on speech is content-based if it applies to particular speech because of the topic discussed or the idea or message expressed. The Names Clause turns on the content of the proposed trademark, whether it contains a person's name. If the trademark does contain a person's name, and the registrant lacks that person's consent, then the Names Clause prohibits registration. Because trademarks containing names are treated differently from trademarks conveying other types of ideas, the Names Clause is content-based. We thus confront a situation we did not address in previous cases. We were careful to leave open the framework for deciding free speech challenges to provisions of the Lanham Act, and we declined to say anything about how to evaluate viewpoint-neutral restrictions on trademark registration. Because we must now consider for the first time the constitutionality of a content-based, but viewpoint-neutral, trademark restriction, we begin by addressing how the nature of trademark law informs the applicable constitutional scrutiny. Although a content-based regulation of speech is presumptively unconstitutional as a general matter, we have not decided whether heightened scrutiny extends to a viewpoint-neutral trademark restriction. Several features of trademark counsel against a per se rule of applying heightened scrutiny to viewpoint-neutral, but content-based trademark regulations. Most importantly, trademark rights have always coexisted with the First Amendment, despite the fact that trademark protection necessarily requires content-based distinctions. Trademark rights have been long recognized by the common law and the chancery courts of England in this country, and by the statutes of some of the states, and that protection continues today. As we all agree, this history informs the understanding that content-based distinctions are an intrinsic feature of trademarks. And, for the duration of that history, the inherently content-based nature of trademark law has never been a cause for constitutional concern. Our country has recognized trademark rights since the founding. At the outset, there were few recorded decisions, and the law developed slowly. Much of early American trademark law was lifted essentially from that of England. The protection of trademarks under English law was an inherently content-based endeavor. For example, an early English law made it lawful for traders to weave their name or affix some known mark in any piece of linen manufacture made by them. A person could be liable for fraud if he sold a product under another person's mark. Although there was an early push for federal legislation to protect trademarks, no such law was enacted during our country's infancy. Instead, trademark law fell largely within the province of the states for the 18th and most of the 19th century. For example, Massachusetts passed a private bill incorporating a cotton corporation on the condition that it affix a label to its goods with the seal of the said corporation. The law also prevented others from using a like seal or label by subjecting them to treble damages. To be sure, for most of our first century, most commerce was local and most consumers therefore knew the source of the goods they purchased. Even as late as 1860, the term trademark really denoted only the name of the manufacturer. There was nonetheless a certain amount of litigation in the state courts in the early 19th century, though it went unrecorded. The first reported American decision that may be described as a trademark case involved a dispute over the content of a mark, and in particular, the use of a person's name. In one case, a seller brought suit against another who sold an allegedly inferior product under the same name. The court held that the seller could be liable for fraud if he passed the product off as that of the plaintiff. In a similar vein, the first reported trademark case in federal court revolved around a trademark's content. The court granted an injunction to prohibit a seller from infringing on the plaintiff's trademark. The explanation provided was that the seller imitated both descriptions of products and labels, and that the principles prohibiting such infringement were at that time very familiar to the profession. Recorded trademark law began to take off in the last decades of the 19th century, and its established content-based nature continued. American commerce became more national in character, and perhaps because of this shift, Congress enacted the first federal trademark law in 1870. Although states retained their important role, Congress stepped in to provide a degree of national uniformity for trademark protection. This first law contained prohibitions on what could be protected as a trademark. For example, the law would not protect a trademark that contained merely the name of a person, unaccompanied by a mark sufficient to distinguish it from the same name when used by other persons. It thus restricted a trademark based upon its content. As trademark disputes increased, courts continued to assess trademarks based on their content. For example, this court's first trademark decision explained that a trademark cannot consist of a purely geographical name, rejecting an attempt by one of several coal producers to trademark Lackawanna coal. Throughout its development, trademark law has required content-based distinctions. That did not change when Congress enacted the Lanham Act in 1946. The Act's comprehensive system for federal registration of trademarks continues to distinguish based on a mark's content. The Act defines a trademark to include any word, name, symbol, or device, or any combination thereof that a person uses to identify and distinguish his or her goods from those manufactured or sold by others, and to indicate the source of the goods. When the government defines what may be registered as a trademark, it necessarily decides that some words or images cannot be used in a mark. To take one example, the Lanham Act bars the registration of a mark which so resembles another's mark as to be likely to cause confusion, or to cause mistake, or to deceive. It is impossible to determine whether one trademark is the same as, or confusingly similar to, another without looking at the content of the two marks. This history, reflected in the Lanham Act still today, demonstrates that restrictions on trademarks have always turned on a mark's content. But, despite its content-based nature, trademark law has existed alongside the First Amendment from the beginning. That long-standing, harmonious relationship suggests that heightened scrutiny need not always apply in this unique context. The content-based nature of trademark protection is compelled by the historical rationales of trademark law. A trademark has generally served two functions: indicating ownership of the goods to which it is affixed and indicating the source or origin of manufacture. Indicating ownership of a good was needed in part to fix responsibility for defective merchandise, and indicating the source of the good helped prospective purchasers make their selections based upon the reputation of both the vendor and the manufacturer. Both goals thus reflect that trademarks developed historically to identify for consumers who sold the goods and who made the goods. In that vein, a basic function of trademark law has always been to prohibit confusion as to the source of goods or services. Indicating ownership and the manufacturing source touch on the content of the mark, i.e., from whom the product came. Policing trademarks to prevent confusion over the source of goods requires looking to the mark's content. Because of the uniquely content-based nature of trademark regulation and the long-standing coexistence of trademark regulation with the First Amendment, we need not evaluate a solely content-based restriction on trademark registration under heightened scrutiny. We've acknowledged that trademark rights and restrictions can play well with the First Amendment. In this case, we do not delineate an exhaustive framework for when a content-based trademark restriction passes muster under the First Amendment. But, in evaluating a solely content-based trademark restriction, we can consider its history and tradition, as we have done before when considering the scope of the First Amendment. The Lanham Act's Names Clause has deep roots in our legal tradition. Our courts have long recognized that trademarks containing names may be restricted. These name restrictions served established principles. This history and tradition is sufficient to conclude that the Names Clause, a content-based, but viewpoint-neutral, trademark restriction, is compatible with the First Amendment. We need look no further in this case. Restrictions on trademarking names have a long history. Such restrictions have historically been grounded in the notion that a person has ownership over his own name, and that he may not be excluded from using that name by another's trademark. It is therefore an elementary principle that every man is entitled to the use of his own name in his own business. The notion that people should be able to use their own name to identify their goods or business is deeply rooted in American mores. Recognizing a person's ownership over his name, the common law restricted the trademarking of names. It prevented a person from trademarking any name, even his own, by itself. In the early years of trademark law, courts recognized that there can be no trademark in the name of a person, because every person has the right to use his own name for the purposes of trade. The common law did, however, allow a person to obtain a trademark containing his own name, with a caveat. A person could not use a mark containing his name to the exclusion of a person with the same name. A person's right to his name cannot be exclusive as to other people bearing the same name. John Smith cannot acquire a trademark that prohibits other John Smiths from using their own names. We see no evidence that the common law afforded protection to a person seeking a trademark of another living person's name. To the contrary, English courts recognized that selling a product under another person's name could be actionable fraud. Even in the absence of fraud, it would be difficult, if not impossible, to square such a right to trademark another person's name with our established understanding that a person may have a right in his own name as a trademark, as against a person of a different name. Relatedly, one could contract for the use of another person's name in his business. Such contracts would make little sense if one could use another living person's name in business at will. The common law approach to trademarking names thus protected only a person's right to use his own name. This common law understanding carried over into federal statutory law. The first federal trademark law contained a requirement that a trademark contain more than merely a name. That requirement remains largely intact. A few decades later, federal trademark law emphasized that nothing herein shall prevent the registration of a trademark otherwise registerable because of its being the name of the applicant. It is thus unsurprising that the Lanham Act included the Names Clause, prohibiting the registration of a mark containing a name identifying a particular living individual except by his written consent. The Names Clause reflects the common law's careful treatment of names when it comes to trademarks. The restriction on trademarking names also reflects trademark law's historical rationale of identifying the source of goods. Trademark protection ensures that consumers know the source of a product and can thus evaluate it based upon the manufacturer's reputation and goodwill. By barring a person from using another's name, the Names Clause reflects the traditional rationale of ensuring that consumers make no mistake about who is responsible for a product. Moreover, the Names Clause respects the established connection between a trademark and its protection of the mark holder's reputation. We have long recognized that a trademark protects the mark holder's reputation. This protection reflects that a mark may acquire value from a person's expenditure of labor, skill, and money. Accordingly, when a person uses another's mark, the owner is robbed of the fruits of the reputation that he had successfully labored to earn. A person's trademark is his authentic seal, and if another uses it, he borrows the owner's reputation, whose quality no longer lies within his own control. This is an injury, even though the borrower does not tarnish it, or divert any sales by its use. For a reputation, like a face, is the symbol of its possessor and creator, and another can use it only as a mask. This connection between a trademark and reputation is even stronger when the mark contains a person's name. Is not a man's name as strong an instance of trademark as can be suggested? In fact, the English common law of trademarks arose from the fact that those who sold goods that were the fruit of their own labor or craftsmanship began to identify those products with their own names. As we have explained, virtually up until the 14th Amendment's adoption, a trademark really denoted only the name of the manufacturer, and this court has long associated names with the goodwill they may bear. The Names Clause thus protects the reputation of the named individual by preventing another person from using his name. Applying these principles, we have recognized that a party has no First Amendment right to piggyback off the goodwill another entity has built in its name. In one case, the court upheld a provision of the Amateur Sports Act of 1978 that prohibited any person from using the word Olympic for certain purposes without the consent of the U.S. Olympic Committee, U.S.C, and subjected violations to the remedies provided in the Lanham Act. The court rejected the argument that the consent requirement violated the First Amendment because Congress reasonably could conclude that the value of the word Olympic was the product of the U.S.C's own talents and energy. Although the petitioner certainly had a First Amendment right to speak on political matters, It lacked the right to exploit the commercial magnetism of the word Olympic and the U.S.C's hard-won efforts in giving that word value. The Names Clause guards a similar interest. By protecting a person's use of his name, the Names Clause secures to the producer the benefits of his good reputation. We conclude that a tradition of restricting the trademarking of names has coexisted with the First Amendment, and the Names Clause fits within that tradition. Though the particulars of the doctrine have shifted over time, the consistent through line is that a person generally had a claim only to his own name. The Names Clause reflects this common law tradition by prohibiting a person from obtaining a trademark of another living person's name without consent, thereby protecting the other's reputation and goodwill. None of this is to say that the government cannot innovate when it comes to trademark law. A firm grounding in traditional trademark law is sufficient to justify the content-based trademark restriction before us, but we do not opine on what may be required or sufficient in other cases. To be sure, as Justice Barrett observes, a case presenting a content-based trademark restriction without a historical analog may require a different approach, but we need not develop such a comprehensive theory to address the relatively simple case before us today. We conclude that the Names Clause is of a piece with a common law tradition regarding the trademarking of names. We see no reason to disturb this long-standing tradition, which supports the restriction of the use of another's name in a trademark. Our colleagues would address the Names Clause with two analogies. Neither is compelling in this case. Under both analogies, the test would boil down to what a judge believes is reasonable in light of the purpose of trademark law. But no matter the approach taken, we all agree that the Names Clause does not violate the First Amendment. Justice Sotomayor would pull strands of precedent together to conclude that heightened scrutiny does not apply to trademark registration because it is a government initiative or benefit. This conclusion rests primarily upon cases in which the government provides a cash subsidy or conditions the use of a public payroll to collect union dues. But those cases occupy a special area of First Amendment case law, and they are far removed from the registration of trademarks. The government benefit cases are an ill fit for the Names Clause, and we would not graft this precedent, which Justice Sotomayor acknowledges is not controlling, onto this trademark dispute. Justice Barrett, echoed by Justice Sotomayor, would import the test that we have used for a limited public forum. Our precedents hold that the government may create a forum that is limited to use by certain groups or dedicated solely to the discussion of certain subjects. Justice Barrett provides little explanation for why that approach makes sense in the trademark context. She simply declares that the limited public forum framework is apt due to the content-based nature of trademark law. Although she attempts to cabin the analogy to the content-based nature, the limited public forum test is quite obviously about creating a forum. And there is reason to doubt that the Federal Trademark Register is analogous to a limited public forum. To start, unlike a speaker in a limited public forum, a mark holder does not communicate with customers on the register. Rather, as the government acknowledges, the register is a way of warning potential infringers that they risk liability if they use the same or confusingly similar marks. The government has also previously asserted that it did not create a forum for speech by providing for the federal registration of trademarks. Without an analogous forum, it is hard to see why the test for a limited public forum should apply. We see no need to adopt a potentially fraught analogy to resolve the Names Clause's constitutionality. Despite the differences in methodology, both Justice Sotomayor and Justice Barrett reached the same conclusion that the Names Clause does not violate the First Amendment. On the bottom line, there is no dispute. Rather than adopt a reasonableness test premised upon loose analogies, however, we conclude that the Names Clause is grounded in a historical tradition sufficient to demonstrate that it does not run afoul of the First Amendment. Our decision today is narrow. We do not set forth a comprehensive framework for judging whether all content-based but viewpoint-neutral trademark restrictions are constitutional. Nor do we suggest that an equivalent history and tradition is required to uphold every content-based trademark restriction. We hold only that history and tradition establish that the particular restriction before us, the Names Clause in Section 1052C, does not violate the First Amendment. Although an occasion may arise when history and tradition cannot alone answer whether a trademark restriction violates the First Amendment, that occasion is not today. In a future case, we can address the distinct question of whether a viewpoint-neutral, content-based trademark restriction is constitutional without such a historical pedigree. The judgment of the Court of Appeals is reversed. Justice Kavanaugh, with whom the Chief Justice joins, concurring in part, I join all but Part 3 of the Court's opinion. I agree with the Court that the Names Clause is constitutional, particularly in light of the long history of restricting the use of another's name in a trademark. In my view, a viewpoint-neutral, content-based trademark restriction might well be constitutional even absent such a historical pedigree. We can address that distinct question as appropriate in a future case. Justice Barrett, with whom Justice Kagan joins, with whom Justice Sotomayor joins as to Parts 1, 2 and 3b, and with whom Justice Jackson joins as to Parts 1 and 2, concurring in part. While I agree with the Court that the Names Clause does not violate the First Amendment, I disagree with some of its reasoning. The Court claims that history and tradition settle the constitutionality of the Names Clause, rendering it unnecessary to adopt a standard for gauging whether a content-based trademark registration restriction abridges the right to free speech. That is wrong twice over. First, the Court's evidence, consisting of loosely related cases from the late 19th and early 20th centuries, does not establish a historical analog for the Names Clause. Second, the Court never explains why hunting for historical forebears on a restriction-by-restriction basis is the right way to analyze the constitutional question. I would adopt a standard, grounded in both trademark law and First Amendment precedent, that reflects the relationship between content-based trademark registration restrictions and free speech. In my view, such restrictions, whether new or old, are permissible so long as they are reasonable in light of the trademark system's purpose of facilitating source identification. Content-based speech regulations are, as a general matter, presumptively unconstitutional. The rationale of the general prohibition is that content discrimination raises the specter that the government may effectively drive certain ideas or viewpoints from the marketplace. But we have also recognized that in certain situations, this presumption is inapplicable, as there is no realistic possibility that official suppression of ideas is afoot. I agree with the Court that content-based trademark registration restrictions do not trigger the presumption of unconstitutionality, because federal trademark law did not exist at the founding, and American trademark law did not develop in earnest until the mid-19th century. I do not take the Court to be making a claim about the original meaning of the Free Speech Clause. But, as the Court implicitly recognizes, the absence of founding-era evidence does not mean that content-based trademark registration restrictions are inherently suspect. More than a century's worth of precedent reflects that trademark law has always been content-based without functioning as a ready tool of government censorship. The First Amendment does not require us to upend this long-standing stable system by treating trademark restrictions as presumptively unconstitutional. As the Court explains, trademark law existed at the founding, albeit in nascent form. From the outset, trademark protection was an inherently content-based endeavor. Early English and American laws prohibited producers from placing another producer's trademark on their goods, a prohibition that depended on comparing the content of the mark with the content of the allegedly infringing use. That alone does not prove that every type of content-based trademark regulation should escape heightened scrutiny. More relevant is that courts and legislatures, in identifying the marks that merit legal protection, have long discriminated on the basis of content. This history, in my view, is key to understanding why we need not evaluate content-based trademark registration restrictions under heightened scrutiny. Once trademark law got off the ground in the mid-19th century, it had an unmistakably content-based character. Thompson v. Winchester, the first reported American trademark case, involved two parties who both sold medicine under the name Thomsonian Medicines. The Court cites this case as reflective of the content-based nature of trademark protection. True, Thompson explained that the defendant could be liable if he had sold his goods under the plaintiff's name as an attempted fraud, but the Court explained that the result would be different if the defendant called his goods Thomsonian as a generic term designating their general character. That was because Thompson, the plaintiff, could not claim an exclusive right to use the name if the term had acquired a generic meaning, descriptive of a general kind, quality, and class of medicines. In other words, whether a word or phrase could qualify for trademark protection depended on its communicative content. Roughly 10 years later, the New York Superior Court further developed this content-based principle in Amoskeag Manufacturing Company v. Spear and Ripley, long regarded as the leading American adjudication of a trademark dispute. The Court agreed that every manufacturer has an unquestionable right to distinguish the goods that he manufactures or sells by a peculiar mark or device, in order that they may be known as his. But the law will only protect him in the exclusive use of marks that designate the true origin or ownership, i.e., the source, of the goods. The manufacturer cannot claim a protectable trademark in words, letters, figures, or symbols that indicate only the name or quality, i.e., not the source, of the goods. After all, those who produce similar goods could use the same words or symbols with equal truth, thus, they should have an equal right to employ them for the same purpose. Courts repeated and applied this rule for decades. For instance, a gin manufacturer could not claim an exclusive right to the term Skadam Schnapps if it already served as a common descriptor of gin. But a stove manufacturer could trademark the term Charter Oak as a distinctive phrase not merely descriptive of the style, quality, or character of the product. Then, as now, Courts understood that a mark merits protection only so far as it identifies the article to which it is affixed as that of the person adopting it and distinguishes it from others. This inquiry is inherently content-based. The ratification of the 14th Amendment in 1868, which incorporated the First Amendment against the states, did not prompt courts to change course. They continued to scrutinize proposed marks based on their content. Likewise, this court's first trademark decision, issued in 1871, invoked content-based criteria to define those trademarks entitled to legal protection. Thus, at the earliest point at which the First Amendment could have applied to trademark law, content discrimination, particularly with respect to the very definition of a trademark, was the norm. Trademark registration restrictions followed suit. Federal registration, though not required to enforce a trademark, confers important legal rights and benefits on trademark owners and thus helps to ensure that trademarks are fully protected. Unsurprisingly, as the court notes, Congress's first trademark statute included certain content-based restrictions for federal registration, and today, each of the Lanham Act's registration criteria refers to the content of the applicant's mark. Thus, just as courts have long identified the criteria for trademark protection along content-based lines, Congress has defined the rules for enhanced trademark protection along content-based lines. The upshot is that content discrimination has long been necessary for trademarks' purposes and limitations. The law protects trademarks because they help consumers identify the goods that they intend to purchase and allow producers to reap the financial rewards associated with their product's good reputation. But trademarks can only fulfill these twin goals if they actually serve as source identifiers, which, as explained above, is a content-based question. These content-based trademark rules have long coexisted with the free speech clause, and their function is generally compatible with it. Courts have applied content-based rules not to suppress ideas, but simply to serve trademark law's purposes. Indeed, these trademark restrictions can actually help prevent interference with the marketplace of ideas, insofar as they ensure that a single producer cannot exclusively appropriate words or phrases in the general domain. This is not to say that the government could not abuse content-based trademark registration restrictions. As I explained below, such restrictions are not insulated from scrutiny, but they do not set off alarm bells signaling the likelihood that official suppression of ideas is afoot. Therefore, I agree with the court that we need not treat content-based trademark registration restrictions as presumptively unconstitutional. Though content-based registration restrictions do not trigger strict scrutiny, they are still subject to judicial review. Thus, we must decide how to evaluate Elster's challenge to the Names Clause. The Solicitor General suggests that we draw an analogy to another area that is inherently content-based, the limited public forum. When the government opens its property to speech for a particular purpose, creating a limited public forum, it necessarily must reserve the property for certain groups or for the discussion of certain topics. Content-based restrictions are inherent and inescapable in maintaining a forum for speech compatible with the intended purpose of the property. It is therefore inappropriate to view these restrictions as presumptively unconstitutional and apply strict scrutiny. Still, not every restriction is permissible. To evaluate these rules, we ask whether they are reasonable in light of the purpose which the forum at issue serves. This ensures that the government respects the lawful boundaries it has itself set. Though I would not shoehorn the trademark registration system into the definition of a limited public forum, the Solicitor General's analogy is apt. Content discrimination is implicit in the concept of the trademark registration system, much like it is in a limited public forum. Federal registration helps protect marks by conferring strong legal rights on mark owners who register them. Congress provided for national protection of trademarks in order to secure to the owner of the mark the goodwill of his business and to protect the ability of consumers to distinguish among competing producers, matching trademarks' historical goals. A mark can only fulfill those goals to the extent that it tells the public who is responsible for the product. This is a content-based requirement. Content-based criteria for trademark registration do not abridge the right to free speech so long as they reasonably relate to the preservation of the mark owner's goodwill and the prevention of consumer confusion. A particular restriction will serve those goals if it helps ensure that registered marks actually function as source identifiers. Notably, the lead criterion for registration is that the mark in fact serve as a trademark to identify and distinguish goods. Other registration criteria help to carry out that threshold requirement. For instance, the Lanham Act prohibits the registration of marks that are merely descriptive of the applicant's goods. As courts frequently explained in the early years of trademark, marks that simply describe the kind and quality of the good do not necessarily identify its source. The bar on registering deceptive marks likewise prevents registered marks from misidentifying the source of the goods. The Names Clause passes muster under this test. A trademark that includes another living person's name without her consent has the obvious potential to create source confusion. Further, the clause helps protect producer goodwill. By freely using another person's name in her mark, the mark owner can unfairly capitalize on the reputation of the named individual, who may be a producer in her own right. Conversely, if the mark owner's goods or services are shoddy, she might jeopardize the named individual's reputation. Elster protests that consumers would not assume that Donald Trump is responsible for the mark Trump too small. Thus, he argues that even if the names clause generally guards against source confusion, refusing to register his proposed mark does not. But Congress is entitled to make categorical judgments, particularly where heightened scrutiny does not apply. The government can reasonably determine that, on the whole, protecting marks that include another living person's name without consent risks undermining the goals of trademark. The names clause is therefore constitutional, both facially and as applied to Elster's mark. Rather than adopt a generally applicable principle, the court assesses the names clause in isolation, treating the supposed history and tradition of the clause as determinative. In my view, the historical record does not alone suffice to demonstrate the clause's constitutionality. For one thing, the record does not support the court's conclusion. For another, I disagree with its choice to treat tradition as dispositive of the First Amendment issue. First, the court's history. It is true that a tradition of restricting the trademarking of names arose in the late 19th century. As the court says, a personal name by itself, without any accompanying words or symbols, did not typically qualify as a trademark, and a person could not always enforce a trademark including her own name against another with the same name. The first federal trademark statute reflected these principles, prohibiting the registration of a mark that was merely the name of a person, firm, or corporation only, unaccompanied by a mark sufficient to distinguish it from the same name when used by other persons. Today, the Lanham Act continues to bar the registration of a mark that is primarily merely a surname. But the court also claims that the common law did not afford protection to a person seeking a trademark including another living person's name, in other words, a rule akin to the names clause. I am less sure. In Thaddeus David's Company v. David's Manufacturing Company, this court explained that the 1905 federal trademark statute contained a fairly complete list of the marks used by dealers in selling their goods, which are not valid trademarks at common law. Notably, this statute did not include the names clause or any rough equivalent. And if such a common law rule existed, the majority opinion does not identify it. Instead, the court draws from sources suggesting that a person could not enforce a trademark with another individual's name against that individual, nor could she fraudulently attempt to pass off her goods as those of another person, using that person's name. So far, so good. Yet the names clause prevents other uses of someone else's name that the common law may have allowed. And on that score, the court does not fully grapple with countervailing evidence. In 1860, the Supreme Court of Rhode Island concluded that the phrase, Roger Williams' long cloth, was capable of distinguishing the manufacturer's goods and thus qualified as a trademark. Roger Williams, though the name of a famous person, the court explained, was, as applied to cotton cloth, a fancy name, as would be the case with any other hero, living or dead. Likewise, a New York court upheld the plaintiff's exclusive right to use the name Bismarck to designate their paper collars, as they were the first to appropriate the name for that purpose. The court thus rejected the defendant's argument that the plaintiffs could not adopt the name of a distinguished German citizen as a trademark. Summarizing, the Second Circuit explained that the law permits the adoption as a trademark of the name of a person who has achieved fame and distinction, provided the name is not descriptive of the quality or the character of the article or a geographical name. See also Medlar and Holmes Shoe Company v. Del Sarte Manufacturing Company. The name of a famous person, used merely as a fancy name, may become an exclusive trademark. The legislative history of the Lanham Act also undercuts the court's conclusion. If the names clause codified an existing common law tradition, one might expect to see some reference to that tradition when the names clause was adopted. But proponents of the clause offered a different justification. Discussing a predecessor version of the clause, Edward Rogers, the Lanham Act's primary drafter, remarked that the idea of prostituting great names by sticking them on all kinds of goods is very distasteful to me. The commissioner of the Patent Office agreed, noting the shock to his sense of propriety to see liberty taken with the names of celebrities of private life. He then referred to the attempted registration of the name of the Duchess of Windsor for brassieres and ladies' underwear. They did not suggest that the common law would already prevent those uses of another's name as a trademark. On the contrary, they seemed most concerned about the types of marks that the common law appeared to allow. It is thus difficult to say that the names clause is constitutional solely because of its historical pedigree. Perhaps recognizing that reality, The court relies not only on the purported common law tradition restricting the trademarking of names, but also points to the names clause's relation to trademarks' historical purposes. The latter argument is quite similar to my own. I agree that the names clause helps to ensure that the proposed mark functions as a source identifier and to guard against reputational consequences, serving trademarks' historical goals. But I cannot agree with the court that the existence of a common law tradition and a historical analog is sufficient to resolve this case. Even if the court's evidence were rock solid, I still would not adopt this approach. To be sure, tradition has a legitimate role to play in constitutional adjudication. For instance, the long-standing practice of the political branches can reinforce our understanding of the Constitution's original meaning. A course of deliberate practice might liquidate ambiguous constitutional provisions. The views of preceding generations can persuade, and, in the realm of stare decisis, even bind. But tradition is not an end in itself, and I fear that the court uses it that way here. The court does not, and could not, argue that the late 19th and early 20th century names restriction tradition serves as evidence of the original meaning of the Free Speech Clause, nor does it treat the history it recites as a persuasive data point. Instead, it presents tradition itself as the constitutional argument. The late 19th and early 20th century evidence is dispositive of the First Amendment issue. Yet what is the theoretical justification for using tradition that way? Relying exclusively on history and tradition may seem like a way of avoiding judge-made tests. But a rule rendering tradition dispositive is itself a judge-made test. And I do not see a good reason to resolve this case using that approach rather than by adopting a generally applicable principle. After all, there is a tradition of the latter approach too. In the course of applying broadly worded texts like the Free Speech Clause, courts must inevitably articulate principles to resolve individual cases. I do not think we can or should avoid doing so here. As I explained in Part 1b, the takeaway from history is that content-based trademark restrictions have long been central to trademarks' purpose of facilitating source identification, and they have not posed a serious risk of censorship. This principle offers a generally applicable way to think about whether registration restriction play well with the First Amendment. We should bring clarity to the law by adopting it. In my view, the court's laser-like focus on the history of this single restriction misses the forest for the trees. It gives secondary billing to what I think is the central point, that the names clause reflects trademark law's historical rationale of identifying the source of goods. I see no reason to proceed based on pedigree rather than principle. Besides, as the court admits, its approach merely delays the inevitable. Eventually, the court will encounter a restriction without a historical analog and be forced to articulate a test for analyzing it. Trademark protection cannot exist without content discrimination. So long as content-based registration restrictions reasonably relate to the purposes of the trademark system, they are constitutional. The names clause clears this bar. I respectfully concur in part. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, concurring in the judgment. This case involves a free speech challenge to a viewpoint-neutral, content-based condition on trademark registration. In deciding how to evaluate this kind of challenge, the court faces two options. Either look only to the history and tradition of the condition or look to trademark law and settled First Amendment precedent. The first option, which asks whether the history of a particular trademark registration bar plays well with the First Amendment, leads this court into uncharted territory that neither party requests. The other guides it through well-trodden terrain. I would follow the well-trodden path. In assessing the constitutionality of the names clause and other trademark registration provisions, I would rely on this court's tried and tested First Amendment precedent. This court has held in a variety of contexts that withholding benefits for content-based, viewpoint-neutral reasons does not violate the Free Speech Clause when the applied criteria are reasonable and the scheme is necessarily content-based. That is the situation here. Content discrimination is an inescapable feature of the trademark system, and federal trademark registration only confers additional benefits on trademark holders. The denial of trademark registration is therefore consistent with the First Amendment if it turns on reasonable, viewpoint-neutral content regulations. Because the names clause satisfies that test, I would uphold the constitutionality of the provision on that ground alone. This case is the latest in a trilogy of challenges to the constitutionality of trademark registration bars in the Lanham Act. In the first two cases, the court struck down as unconstitutional certain registration bars that discriminated based on viewpoint. Because those cases involved viewpoint-based provisions, there was no occasion to consider the framework for how to evaluate viewpoint-neutral restrictions on trademark registration. This case, by contrast, presents that very circumstance, a viewpoint-neutral, content-based condition on trademark registration. The Names Clause prohibits registration of a mark that consists of or comprises a name identifying a particular living individual except by his written consent. No one disputes that the names clause is content-based. Its application turns, after all, on the mark's content, i.e., whether it identifies by name a particular living individual without his or her written consent. The names clause is also viewpoint neutral because it is agnostic as to how the name in the mark is being used and does not distinguish between two opposed sets of ideas. On these points, and on the conclusion that the names clause is constitutional, we all agree. Our disagreement boils down primarily to methodology. Those familiar with this trilogy of First Amendment challenges to the Lanham Act may be surprised, perhaps even disappointed, to learn that, although this case presents the situation we did not address in earlier cases, the court has shied away from setting forth a framework for deciding free speech challenges to provisions of the Lanham Act. Yet perhaps the biggest surprise, and disappointment, of today's 5-justice majority opinion is its reliance on history and tradition as a dispositive test to resolve this case. In holding that the names clause is constitutional, that majority asserts that one need look only to the history and tradition of the clause and no further. Why look to history and tradition alone? Because, the majority says, it is sufficient to conclude that the names clause is compatible with the First Amendment, considering this court has never applied this kind of history and tradition test to a free speech challenge, and that no one briefed, argued, or even hinted at the rule that the court announces today. One would have expected a more satisfactory explanation. There is none grounded in our First Amendment doctrine and precedent. One justice questions the majority's explanation in part by claiming that, if anything, the court's evidence does not establish a historical analog for the names clause. That may well be true, yet this back and forth highlights the indeterminacy of the court's history and tradition inquiry, which one might aptly describe as the equivalent of entering a crowded cocktail party and looking over everyone's heads to find your friends. To make matters worse, the 5-justice majority that undertakes this tradition as dispositive inquiry found its friends in a crowded party to which it was not invited. That majority has drawn conclusive inferences from its historical evidence, all without any guidance from the litigants or the court below. That stark departure from settled principles of party presentation and adversarial testing in favor of in-chambers historical research by non-historians raises more questions than answers. It is not appropriate, much less necessary, to find common law analogs to settle the constitutionality of the names clause or any other trademark registration provision. I agree with the assertion that, even if the majority's historical evidence were rock solid, there is no good reason to believe that hunting for historical forebears on a restriction-by-restriction basis is the right way to analyze the constitutional question. The majority attempts to reassure litigants and the lower courts that a history-focused approach here is sensible and workable, by citing to recent precedent. To say that such reassurance is not comforting would be an understatement. One need only read a handful of lower court decisions applying that precedent to appreciate the confusion this court has caused. Ultimately, I am reluctant to go further down this precipice of looking for questionable historical analogs to resolve the constitutionality of Congress's legislation. To borrow Justice Scalia's criticism from a different context, such hunting far into the dim past is not just a waste of research time and ink but also a false and disruptive lesson in the law that condemns litigants, who, unlike us, must pay for it out of their own pockets, to subsidizing historical research by lawyers. I would instead apply this court's First Amendment precedent, just as the parties did in arguing this case. The most straightforward way to resolve this and other free speech challenges to trademark registration criteria is through a doctrinal framework drawn from this court's First Amendment precedent. The analysis should proceed in 2 steps. First, ask whether the challenged provision targets particular views taken by speakers on a given subject. If the trademark registration bar is viewpoint-based, it is presumptively unconstitutional and heightened scrutiny applies. If it is viewpoint neutral, however, the trademark registration bar need only be reasonable in light of the purpose of the trademark system. Specifically, the trademark registration bar must reasonably serve its purpose of identifying and distinguishing goods for the public. If the challenged provision is both viewpoint neutral and reasonable, then it does not violate the free speech clause. This court has applied strict constitutional scrutiny to viewpoint-neutral content classifications on some occasions, and thus treated them as presumptively unconstitutional. It has declined to do so, however, when any risk that such classification will impermissibly interfere with the marketplace of ideas is attenuated, that is, when there is no realistic possibility that official suppression of ideas is afoot. In those cases, the difference between viewpoint-based and viewpoint-neutral content discrimination can be decisive. This is such a case, whereas the denial of trademark registration under viewpoint and content-based criteria is presumptively unconstitutional under heightened scrutiny. A denial under viewpoint-neutral, content-based criteria is not constitutionally suspect and does not trigger the same exacting scrutiny. In explaining why the difference is decisive in this context, the court and Justice Barrett emphasized that trademarks are inherently content-based, yet have long coexisted with the First Amendment. I agree with the use of historical evidence to support this point. History informs the understanding that content-based distinctions are an intrinsic feature of trademarks, and that the mark's purpose is to identify and distinguish goods for the public. That use of history is legitimate and in fact valuable, just as evidence of a long-standing practice of government can inform the meaning of constitutional provisions in appropriate cases. That is not how the 5-justice majority is using history, however. The majority instead treats a disputed, and isolated, account of the history and tradition of the Names Clause as determinative of its constitutionality. It is that judge-made test that is unmoored from constitutional text and precedent, and which I repudiate as unhelpful. Even then, history does not give us the full story. The assertion that content-based distinctions in trademark law have long played well with the First Amendment, although true, requires a more fulsome explanation, particularly as applied to the trademark registration system. The primary reason why viewpoint-neutral trademark registration criteria easily coexist with the Free Speech Clause is that they do not burden expression. Instead, a denial of registration withholds ancillary benefits that might bolster someone's expression. When a government confers a benefit that supports some forms of expressive activity, the decision to withhold that benefit on viewpoint-neutral grounds cannot be equated with the imposition of a penalty on that activity, which would trigger heightened scrutiny. The First Amendment protects the freedom of speech. It does not require the government to give aid and comfort to those using particular modes of expression. Indeed, this court has recognized repeatedly that the First Amendment permits governmental bodies to rely on reasonable, viewpoint-neutral, content-based criteria when deciding to benefit certain communicative activities. As I explained in Brunetti, and the Solicitor General argues in this case, various strands of precedent support this point, ranging from cases about limited public or non-public forums to those involving monetary subsidies and non-cash governmental programs. In these cases, content discrimination was necessarily a part of the governmental initiative at issue, yet the initiative was not subject to the constitutional straitjacket of heightened scrutiny. That was so because each initiative supported some forms of expression without restricting others. Some speakers were better off, but no speakers were worse off. These cases may not be controlling here in a strict sense, yet they do provide some instruction. They generally stand for the proposition that the Free Speech Clause permits governmental bodies to impose a reasonable, viewpoint-neutral limitation on a state-bestowed entitlement. Someone with a federally registered mark enjoys certain benefits by virtue of that registration. Even so, free speech is not abridged when these benefits are denied to someone based on reasonable, viewpoint-neutral criteria. Consider three basic tenets of trademark law, each of which the court rightly acknowledges. First, every trademark's primary function is to tell the public who is responsible for a particular product, that is, to serve as a source identifier. Although trademarks may also communicate a message, that message is only incidental to what a trademark is and does. Second, federal law does not create trademarks. Rather, by virtue of common law, the first person to use a distinct mark in commerce acquires rights to that mark, including exclusivity rights to prevent others from using the mark. Third, federal registration provides increased trademark protection only by conferring additional benefits on trademark holders. For example, it provides nationwide constructive notice of the registrant's claim of ownership of the mark, which forecloses some defenses in infringement actions, and constitutes prima facie evidence of the mark's validity and exclusivity in commerce. To be sure, nothing in the Constitution requires these predominantly commercial benefits. One conclusion follows from these three principles: by prohibiting trademark registration for viewpoint-neutral, content-based reasons, Congress simply denies an applicant the opportunity to include his mark on a list and secure certain benefits that are useful in infringement litigation. The risk of speech suppression is therefore attenuated because denying a trademark holder these ancillary benefits does not prevent him from using his mark in commerce or communicating any message incidental to the mark. Now consider the facts of this case. Respondent Steve Elster wants to sell shirts with the phrase "Trump too small" on them. He also wants increased trademark protection by federally registering the phrase. In the registration request, Elster explained that the phrase invokes a memorable exchange between President Trump and Senator Marco Rubio from a 2016 presidential primary debate and aims to convey that some features of President Trump and his policies are diminutive. When the U.S. Patent and Trademark Office rejected the registration request, it denied Elster the opportunity to secure the government-bestowed benefits associated with registration. Critically, the denial did not prevent Elster from communicating his message. It also did not restrict his preferred mode of expression. Elster can still sell shirts displaying the same message. Elster could also use a different phrase, such as Elster apparel, as a source identifier to obtain the desired benefits of registration while continuing to sell shirts with his preferred message across the front. Put simply, the denial only barred Elster from registering a mark asserting exclusive rights in another person's name without their written consent. Because trademark registration criteria limit statutory benefits in a necessarily content-based scheme, the First Amendment requires the criteria to be viewpoint neutral and reasonable. From this court's analogous non-public forum and limited public forum cases, it is clear that reasonable means that the challenged provision must reasonably serve the purpose of the content-based scheme. On this point, I agree with Justice Barrett that the challenged trademark registration criteria must be reasonable in light of the trademark system's purpose of facilitating source identification. In Cornelius, for example, the court confronted a free speech challenge to the government's decision to exclude legal defense and political advocacy organizations from participation in the combined federal campaign, a charity drive aimed at federal employees. After concluding that the campaign was a non-public forum not dedicated to general debate or the free exchange of ideas, the court held that the First Amendment permits content and speaker-based distinctions so long as they are reasonable in light of the purpose served by the forum and are viewpoint neutral. Importantly, the decision to restrict access need not be the most reasonable or the only reasonable limitation. Based on this test, the court ultimately concluded that the government acted reasonably and consistent with the Free Speech Clause in limiting participation in the campaign in order to minimize disruption to the federal workplace, to ensure the success of the fundraising effort, or to avoid the appearance of political favoritism without regard to the viewpoint of the excluded groups. Justice Thomas, joined by 2 justices, rejects this test, implying that it is subjective because it supposedly turns on what a given judge might think is reasonable. That statement misunderstands the inquiry. As just discussed, a trademark registration condition is reasonable if it serves as a source identifier, a concept that is familiar to anyone who has worked on a trademark case. More generally, this kind of reasonableness inquiry appears in every limited public, or non-public, forum case. Far from being subjective and unworkable, this kind of test goes to the very core of what judges and lawyers do every day. When contrasted to their preferred history-driven approach, the criticism of the reasonableness inquiry is even more unpersuasive. As discussed above, the history and tradition approach is not just flawed as a matter of first principles, but also highly indeterminate and unfamiliar to judges and litigants in this area of the law. How much history is enough to clear the historical analog bar the 5-justice majority set up? What does that look like in this context? When it comes to subjectivity, their preferred approach empowers judges to pick their friends in a crowded party. When faced with the 2 options, I choose the test that is rooted in this court's First Amendment doctrine and precedent, is attuned to what judges and lawyers are properly trained to do, and does not limit Congress from dealing with modern-day conditions based on the foresight of yesterday's generation. Content-based criteria for trademark registration do not abridge the right to free speech so long as they reasonably relate to the preservation of the mark owner's goodwill and the prevention of consumer confusion. Goals that a particular restriction will serve, if it helps ensure that registered marks actually function as source identifiers. The Names Clause easily passes this reasonableness test. Source identification is, after all, at the heart of what the Names Clause does. Imagine someone who wants to manufacture and sell the best bats and catcher's mitts in baseball. Unsurprisingly, that person wants to use the names of Derek Jeter and Jorge Posada to capitalize on their goodwill to promote the products. So, the manufacturer lands on Jeter out of the park and catch like Posada as marks. The Names Clause bars registration of these phrases without the named individual's written consent. It does so for good reason. Jeter and Posada may not want consumers to misattribute these products to them, just as consumers may not want to buy products under the false pretense that these goods somehow are connected to the players. Source identification is especially important when, for example, the named individual produces similar products. Say, Jeter and Posada sell their own baseball goods under the marks Mr. November Bats by Jeter and Champs Mitts by Posada. They would not want manufacturers to dilute the commercial value of their name and reputation, nor would Jeter and Posada want a Boston Red Sox fan to manufacture cheaper goods and use their names to promote second-rate products. The Names Clause prevents that from happening. Congress was entitled to make this legislative judgment. The government, after all, has a reasonable interest in refraining from lending its ancillary support to marks that use an unconsenting individual's name for commercial gain. In sum, the Names Clause is constitutional because it is a viewpoint-neutral, reasonable limitation on a trademark's registration. The court's decision today is narrow, and its history and tradition test is good only for the relatively simple case before us today. Ultimately, all 9 justices agree that Congress can innovate when it comes to trademark law, And we further agree that nothing in today's opinion calls into question the constitutionality of viewpoint-neutral provisions lacking a historical pedigree. For the reasons set forth above, I respectfully concur in the judgment. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.